Welcome back to the deep dive. Today we're really undertaking a critical mission. You supplied us with a single but incredibly detailed source, a report on a major civil rights lawsuit. And we're using that document, all 72 pages of it, as our map to navigate one of the most intense intersections of U.S. immigration enforcement and constitutional law that's playing out right now.
That's right. We are zeroing in on the Twin Cities area in Minnesota. This is where the American Civil Liberties Union, the ACLU, has launched this extraordinary challenge against federal authorities.
Right.
And what makes this so compelling and, frankly, so alarming is that this isn't just some political argument about border policy.
No.
It's a detailed legal allegation
Yeah.
about profound constitutional violations against people who are, explicitly named and confirmed as U.S. citizens.
Okay, so let's unpack this right away. The scope here is just massive. We've got this 72-page lawsuit. It was filed in the immediate context of Thursday, January 15th, 2026, against the Trump administration. And the defendants are high level. We're talking the Department of Homeland Security, DHS, and Customs and Border Protection, CBP. So our mission for you, the listener, is to cut through all the legal jargon and the, frankly, very sharp political noise to get to three key things. The core legal claims, the specific visceral human cost we see in the plaintiff's stories, and then these intensely dueling narratives between the federal government and local officials.
Exactly. The core mission today is to pull out the most critical facts, the things that detail how U.S. citizens allegedly had their fundamental constitutional rights violated.
The big ones.
The big ones. We're talking about the Fourth Amendment, which is, protection against unreasonable searches and seizures.
Right.
And the Fifth Amendment, due process, protection of liberty. The essential aha moment of this whole complaint, if you boil it down, is this idea that in an enforcement campaign that was supposed to target non-citizens created what the ACLU calls a crude dragnet.
A crude dragnet.
And this operation, they argue, was so indiscriminate, so reliant on racial profiling, that it just inevitably swept up U.S. citizens. It restrained them, shackled them, traumatized them based on nothing more than their race.
That concept that the lack of precision is itself a constitutional violation, that's profound. So for you, the listener, we've structured this dive to give you maximum clarity. We'll start by dissecting the legal filing itself. Who is the ACLU suing? What are the legal claims? What does a 72-page complaint really mean?
Right.
Then we'll move into Section 2. This is where we go deep on two specific, really dramatic anecdotes from the plaintiffs that anchor the whole case. This is where it becomes real.
Yeah, that's where the abstract becomes palpable.
Exactly. And finally, we'll analyze the high-level political fight, contrasting the administration's official justification for these surge operations against the, just incredibly sharp condemnation coming from Minnesota's own state and local officials.
Let's get into it. So to start with the structure of the conflict, the organization driving this is the ACLU. And they're making a strong stand here, not just on immigration policy, but on core civil rights and liberties.
And the defendants they chose, it seems very strategic.
Highly strategic. It's not just, a few individual officers on the ground, though they are included as unnamed CBP officers.
Right. The John Does.
Exactly.
And
the suit targets the entire administrative apparatus.
Yes, the defendants are high level. The Trump administration, the Department of Homeland Security, and DHS Secretary Kristi Noem specifically. Why is that significant? Why name the secretary and not just, say, a regional director?
Naming the secretary, or really any cabinet member, is a signal. It says the ACLU is challenging not just the actions of a few rogue agents, but the policies, the procedures, the institutional culture that allowed these alleged abuses to even happen. When you sue the secretary, you're saying the problem is systemic. It's the operational guidelines, the authorization for this surge, the training, or lack thereof, that are flawed from the top down.
So the goal is systemic change, not just getting damages for 3 people.
Precisely.
And what's fascinating is the sheer weight of this filing.
Yeah.
A 72-page lawsuit. And the plaintiffs, they're not ambiguous cases. They are 3 named community members, all confirmed U.S. citizens. That's the whole legal fulcrum here.
It is.
The primary legal claim is stark. Federal immigration agents are violating the constitutional rights of U.S. citizens.
It's really more than just a challenge to a policy. It's a direct challenge to the legality of the methods being used in the Twin Cities. For you, the listener, you have to understand the legal stakes here. The government, it has wide latitude in enforcing immigration law, but
there's a line.
There's a hard line. And that latitude absolutely vanishes the moment they unlawfully detain a U.S. citizen.
Yeah.
The lawsuit is saying you crossed that line.
And the document's language, I mean, it is not cautious at all. It describes a startling pattern of abuse spearheaded by the Department of Homeland Security that is fundamentally altering civic life in the Twin Cities and the state of Minnesota. That phrase, fundamentally altering civic life, we need to hang on to that one.
We do.
It speaks to this deep, generalized corrosion of trust and safety that goes way beyond just the three plaintiffs.
It connects the individual injury to the communal injury. The ACLU is arguing that these enforcement ops have moved beyond law enforcement and into what they're calling a campaign of psychological warfare against entire communities.
Which shifts the harm from a simple illegal arrest to a widespread civil rights catastrophe.
That's the argument.
So let's talk about that catastrophe specifically, because the lawsuit details how these communities were allegedly chosen. This is the racial profiling charge.
This is the core of it.
The ACLU claims these operations are not based on intelligence or warrants, but on, visible ethnic and racial characteristics.
Precisely. The lawsuit claims explicitly that Somali and Latino communities in Minnesota have been disproportionately targeted. This is a statistical claim, it's an anecdotal claim, and it suggests a clear bias in where they deploy these agents.
And the description of the tactics themselves paints a pretty chilling picture.
It does. The document alleges, and I'm quoting here, masked federal agents in the thousands are violently stopping and arresting countless Minnesotans based on nothing more than their race and perceived ethnicity, irrespective of their citizenship or immigration status.
So that's the legal mechanism they're attacking. Race, not individualized suspicion, is the operating principle. But what does that mean legally when an operation is that indiscriminate? Is the ACLU saying the lack of precision is the violation itself?
That is exactly the point. The Fourth Amendment requires that any seizure and a stop or detention is a seizure.
Right.
It must be based on reasonable suspicion or probable cause. And probable cause requires specific facts suggesting that specific person has committed a crime.
Not just that they look a certain way.
Exactly. If the only thing an agent is relying on is skin color, or that they're in a predominantly Somali neighborhood, the stop is arbitrary. It's unconstitutional. The lack of precision is a violation because it's using race as a substitute for individualized probable cause.
And that phrase, masked federal agents in the thousands, that suggests this overwhelming, almost quasi-military presence in civilian areas.
It does. And that leads right to the ACLU's central theory, what they call the crude dragnet concept.
Okay.
The lawsuit says this operation's scope is so broad, so indiscriminate a dragnet cast across entire neighborhoods that it inherently lacks the required constitutional precision. It argues this dragnet not only arrests non-citizens without warrants, but it also sweeps in numerous U.S. citizens in the process.
So this is the legal vulnerability of racial profiling. If you rely on a general profile, you inherently accept the risk you're going to violate the rights of citizens who fit that profile.
You're designing a system that is constitutionally guaranteed to fail.
Right.
And the source material highlights the specific actionable abuse alleged against these citizens once they're caught in that dragnet. The allegations are very concrete. Citizens are shackled, they have their faces scanned, and critically, their documents or even just their verbal statements of U.S. citizenship are ignored.
Okay, let's draw a distinction here because this feels crucial. If an agent ignores a physical ID, a passport, a birth certificate, that seems like a clear violation. Bad faith.
Obvious Fourth Amendment violation, yes.
But what about just ignoring a verbal claim of citizenship? Where's the legal line on that?
That's key to the due process claim under the Fifth Amendment. When a person is stopped, they have a right to identify themselves. If a citizen says, I am a U.S. citizen, the agent has a constitutional obligation to take reasonable steps to check that claim before escalating to a detention or arrest.
I see.
The lawsuit alleges that agents cross that line the moment they refuse to check an ID or even acknowledge the claim, and instead proceed based on racial prejudice. Ignoring the verbal claim is evidence that the operation's real motive is bias, not a genuine law enforcement inquiry.
So if they're shackling and transporting citizens, they're operating on an assumption of guilt, no matter what the individual says.
That's the allegation.
Which brings us right to the human core of this lawsuit. That move from the, abstract legal language of a 72-page complaint to the specific human stories. That's what makes these constitutional arguments come alive.
It really is.
For you, the learner, these details are the anchors of the case. They make these rights feel palpable. So let's start with the first plaintiff, Mubashir Khalif Hussein.
Mubashir Khalif Hussein is identified in the source as a 20-year-old U.S. citizen. His story begins last December. He was doing the most mundane thing you can imagine.
What was that?
Walking to lunch in Minneapolis's Cedar Riverside neighborhood. A totally routine, everyday activity that, according to the lawsuit, turned violent immediately.
He was detained by masked ICE agents. So when that happens, what does the Fourth Amendment allow? He did what he was supposed to do. He repeatedly said, "I'm a citizen."
And the agent's alleged response is the exact legal problem. They allegedly refused to check his ID, refused to even acknowledge his claims of citizenship. That failure to do even the minimal verification is the first critical legal failing. But instead of de-escalating, the agents allegedly used force.
The headlock.
They placed him in a headlock, and then they transported him to the Whipple Federal Building in South Minneapolis.
Let's just pause on the headlock for a second. We're talking about physical force on a young man who isn't resisting arrest. He's identifying himself as a citizen. How does that specific action strengthen the ACLU's case for excessive force?
It transforms the stop from a questionable detention into an outright excessive force claim. The Fourth Amendment says any force used has to be reasonable relative to the threat.
Right.
If you're detaining a U.S. citizen who is just walking and stating his identity, a headlock is, it's prima facie excessive. It suggests the agents were operating with a degree of aggression that was totally unwarranted, which again suggests that bias, not security, was the real motive.
And once he was in custody, it continued. He was shackled, fingerprinted, and the lawsuit says he was denied medical assistance and water before he was finally released.
Absolutely. Shackling and fingerprinting someone you have no probable cause to detain, that's a severe intrusion on liberty.
And who has told you he's a citizen?
Repeatedly. And then denying medical assistance, especially after a headlock, that raises separate due process violations about humane treatment in federal custody. All these detailed together demonstrate a pattern of punitive action against someone whose only crime was fitting a racial profile.
And his own words from the ACLU press release just drive home the total lack of due process.
It's a devastating indictment. Husson said, and I'm quoting, "At no time did any officer ask me whether I was a citizen or if I had any immigration status. They did not ask for any identifying information, nor did they ask about my ties to the community or anything else about my circumstances."
The implication is so clear. If you're not asking for ID, if you're not asking about community ties, anything that would establish probable cause, then you are operating purely on visual assumptions, on race and ethnicity. That statement is the core evidence for the profiling claim.
It also shows a fundamental failure of their own stated mission.
How so?
Well, if their goal is to target people here illegally or with criminal records, but they refuse to ask the basic questions to verify that, then the whole operation is legally dubious. They're essentially admitting that his perceived ethnicity was enough to detain him.
Now, here is where the story takes a turn that's just. It's fascinating in terms of escalation and potential retaliation. After his release, Husson was involved in another incident. This was earlier this month, relative to the January 15th article date.
Yes, and this second incident raises profound First Amendment questions. Husson was on a public sidewalk, engaging in protected activity. He was recording ICE officers who were interacting with some protesters nearby.
Okay, totally legal.
Totally legal. The lawsuit alleges that a car with federal agents drove past him, one of them rolled down the window, and pepper sprayed Husson directly in the face.
Wow. Let's talk about the legal magnitude of that. The first incident was an unlawful detention. This second one, if it's proven, is an alleged use of force against a citizen who they'd already processed and released. It seems like they were targeting him specifically for filming them.
And that shifts the legal focus from the Fourth Amendment's unreasonable seizure to a First Amendment retaliation claim.
Right.
The right to record police or federal agents in public is well established. If an agent intentionally used force, like pepper spray, to punish Husson for exercising that right, it's an egregious violation of his liberties.
But isn't it almost impossible to prove that the agent recognized him from before and was intentionally retaliating?
It's a tough evidentiary hurdle, sure, but the lawsuit is likely relying on the pattern of behavior. If Husson can establish he was targeted because he was recording, which is a documented way to draw hostility from law enforcement, and you add in his prior experience with the same agency, the ACLU can argue the use of force wasn't random. It was part of a retaliatory campaign against people trying to hold them accountable.
And the fact that the initial detention was allegedly based on racial profiling just adds more weight to the idea that this subsequent action was also motivated by bias.
Exactly.
The scope of the alleged abuse just gets clearer when we look at the second plaintiff, Mohammed Adoris. His case, he's a 25-year-old U.S. citizen, and it gives us a direct look at the targeting of specific ethnic and linguistic groups.
Right. Adoris's detention happened last month. And again, the circumstances are completely benign. He was shoveling snow out of his parking space after work. His mother was with him.
Okay.
And they were suddenly surrounded by several unidentified, masked federal agents, all in plain clothes. And that's another crucial detail, masked and unidentified.
The lack of protocol here is a huge point of contention. The agents allegedly didn't identify themselves, which is, critical for accountability. They didn't have a warrant.
No.
Instead, they just immediately demand ID to make sure Adoris was not illegal and started questioning his mother.
And that immediate demand for papers, without stating any authority or probable cause, is the very definition of an unreasonable seizure violation.
And the allegations get even more concerning. They get into alleged cultural and religious harassment.
They do. The lawsuit alleges that agents instructed Adoris's mother to remove her niqab, her religious face covering.
The detail about the niqab, that moves this case beyond just immigration status and straight into religious freedom, doesn't it?
Absolutely. It elevates the constitutional violation into the First Amendment sphere.
It suggests an intent to humiliate.
It does. A demand to remove a religious garment without any stated security reason that couldn't be satisfied another way is a clear allegation of religious discrimination. It argues the agents were focused on asserting dominance and prejudice over a visibly Muslim woman, not on verifying legal status.
And the interrogation didn't stop there. They separated the mother and son and then questioned them about the language they were speaking.
Yes, they allegedly asked why they were speaking Somali, which the agents called a foreign language.
That specific detail, questioning their use of Somali, is just such clear evidence of linguistic and ethnic profiling.
It is. It sends a message that belonging is conditional on language, which has no bearing at all on U.S. citizenship.
The message is, if you look a certain way and you sound a certain way, you are suspicious.
Exactly. It reinforces the ACLU's whole position that the agents were just relying on these crude ethnic markers to conduct sweeps.
And then the agents just left, without an arrest, without any explanation.
Right, which mirrors Hassan's experience. A traumatic, high-stress encounter that ends with no procedural justification, leaving the victim with the knowledge they were targeted solely for how they look, speak, or worship.
So if we connect this back to the legal filing, the experiences of Hassan and Adoris are the concrete evidence for that crude dragnet theory.
They are. Their status as U.S. citizens makes the alleged constitutional violation crystal clear. Yeah. This isn't theoretical. This is specific harm from specific operational choices.
When a lawsuit of this magnitude is filed against a federal agency, especially one operating so visibly, the legal and political rhetoric just gets turned up to 11.
It really does.
So we've established the constitutional core of the ACLU's argument. Now let's look at how the opposing parties are framing this legally and politically.
Yeah, let's start with the ACLU's stance. They know the emotional power of these anecdotes, and their lawyers are using language that goes way beyond a simple legal complaint. It's a moral critique.
The ACLU Minnesota attorney, Catherine Allen Halverson, she did not mince words. She said IC and CBP's practices are illegal and morally reprehensible. She called it a grave violation of Minnesotans' most fundamental rights and said it spread fear among immigrant communities.
And that framing, combining illegal, the legal standard, with morally reprehensible, the ethical one, it really sets the tone for the severity of what they're alleging.
And that was amplified by Kate Huddleston from the ACLU's Immigrants' Rights Project. She explicitly tied these actions to anti-constitutional principles, saying the government cannot stop and arrest people based on skin color or without probable cause. And then she used this phrase, police state tactics.
Right.
Police state tactics that's a loaded term. What is the ACLU trying to achieve by using language that strong?
They're trying to define the institutional culture, not just the individual acts. Police state tactics suggests a systematic disregard for constitutional limits, warrantless arrests, unidentified agents, racial targeting. It suggests a system that is fundamentally incompatible with a democracy.
So they're asking the court not just to stop a bad practice, but to recognize that the entire operation is a deviation from constitutional norms.
Exactly. They're positioning this as a defense of the bedrock of the U.S. legal system.
Okay, so on one side, we have this framing of a fundamental breakdown of civil rights. Now we have to turn to the other side, the Trump administration's defense.
Right. And maintaining our neutrality here, we just have to report their stated justification from the source material. The administration robustly defended these operations. They said they are targeting people living in the U.S. illegally, particularly those with criminal records. That's the primary justification.
Public safety.
Public safety. And second, they claim the operations were also aimed at tackling widespread fraud.
So the official line is, these are necessary, legal, targeted operations to fight crime and fraud, not racial profiling. But given the testimony of Hassan and Idoris, the headlock, the pepper spray, the niqab, how credible is that claim of precision?
And that is the ultimate tension the lawsuit is designed to exploit. The credibility gap between the official stated mission and the alleged reality on the ground is just vast.
Right.
The ACLU is arguing that if your operations are so sloppy they're abusing confirmed U.S. citizens, then your claim of precision is just gone. And the stated goal becomes a pretext for unlawful racial targeting. The court has to reconcile those two opposing versions of reality.
And the source material makes it clear that the federal justification was sharply disputed by local authorities.
Yes.
The ones who are actually seeing the on-the-ground impact. This created a serious federal-state crisis.
Minnesota's governor, Tim Walz, and other local officials were incredibly vocal. They characterized the surge of federal agents using severe, legally charged language. They called it an unconstitutional and harmful federal invasion and a campaign of retribution.
Federal invasion. That is a term loaded with implications of federalism and sovereignty. What does it mean for a state governor to accuse the federal government of an invasion inside their own borders?
It signifies a complete collapse of cooperative federalism. It's a rejection of the legitimacy of the federal presence.
Wow.
In constitutional law, calling something an invasion invokes ideas of military action, of hostile occupation. Walz is basically saying that the manner of the Operation Mask agents, no identification, alleged violations, strips it of any lawful foundation. He's treating the federal officers as unauthorized agents of violence.
And the local concern that informs that strong language is tied directly to the impact on residents. They said these operations have terrorized communities and violated residents' rights.
Which establishes this profound conflict of authority. If federal enforcement is labeled an invasion by the governor, it suggests the state government sees them as a hostile force.
Right.
And that has immediate and practical implications for local police, who now have to decide whether to cooperate with or actively obstruct what their own governor is calling an unconstitutional campaign.
And we also have to place all of this in the context of recent scrutiny and violence, which just intensified the whole climate.
Absolutely. The operations came under intense scrutiny because of a recent high-profile incident, the killing of Renee Good, a 37-year-old mother, by a federal agent.
And that did two things. First, it sparked these intense protests, raising the political temperature everywhere.
It did. And second, it forced the Department of Homeland Security to offer a direct defense of their use of force. DHS stated its agents acted lawfully and in self-defense when confronted or threatened.
So you have these two deeply contradictory narratives. The local government sees an unconstitutional invasion and terror tactics. The federal government sees a necessary, lawful operation facing resistance where agents acted in self-defense.
And the ACLU lawsuit, followed right in the middle of all this, becomes the legal mechanism to force a court to decide which version of events is supported by the evidence.
Now that we've unpacked the legal filing, the human cost, and these dueling political narratives, we need to address the central question this lawsuit poses for you, the learner. What does the ACLU mean when it says this is fundamentally altering civic life?
If we connect this back to the bigger picture, it's about the decay of the social contract. We're talking about the chilling effect. When masked, unidentified agents use force, ignore citizenship, and question religious coverings, it sends a signal that your rights are conditional.
Right, negotiable based on how you look.
Exactly. And what does that mean practically for people in the Somali and Latino communities? How does that chilling effect actually show up?
It manifests as withdrawal.
It does. The fear makes people less likely to interact with any authority.
So even local police.
Even local police, who are completely separate from ICE. A family who hears Hassan's story might not report a burglary. They might not take their kids to a clinic fearing registration.
They avoid public spaces.
Right. And this withdrawal starves the entire civic structure, schools, hospitals, local government, of the trust it needs to function. When citizens fear their own government, civic life is fundamentally altered.
And that ties directly into the trauma we heard about from Hassan and Idoris. Citizens being denied their status, shackled, questioned about their native language. It doesn't just damage the individual, it raises a terrifying question for everyone in that community.
Exactly. The question becomes, If my passport can be ignored, if my verbal claim is dismissed, what fundamental right do I actually have? When the state allegedly uses race as the basis for detention, it challenges the very definition of who was protected under the law.
It creates a class of citizens who are functionally treated as non-citizens,
Which erodes the equal protection guarantees of the Constitution.
This leads us right to the heart of the legal vulnerability here, the critical role of citizenship in enforcement. If the operation is supposed to be targeting non-citizens or criminals, how can agents justify ignoring repeated claims of citizenship?
The significance of U.S. citizens being swept up is enormous legally, because it demonstrates the constitutional failure of the operation itself. When agents allegedly refuse to check ID, they undermine the entire procedural premise of their search.
Because the Fourth Amendment requires probable cause.
And if the only evidence for probable cause is a person's perceived ethnicity, any resulting arrest is, by definition, unlawful. When that person turns out to be a citizen, the constitutional implications are just amplified profoundly.
It transforms a potential error into a systemic civil rights violation.
That's the argument.
So let's look ahead. If the ACLU is successful in proving this startling pattern of abuse, what are the potential long-term consequences? What kind of relief would they be seeking?
A successful outcome here would be groundbreaking. It could severely restrict the scope and methods of federal immigration enforcement, especially in diverse urban areas away from the border. The key legal remedy they'll seek is likely a permanent injunction.
Okay, let's define that for the listener. What exactly is a permanent injunction in this context?
An injunction is a powerful court order that tells a party, in this case DHS, to either stop doing this thing or start doing this thing differently.
And a permanent one means it's indefinite.
It remains in effect indefinitely, yeah. And in this case, the injunction would likely mandate specific court-supervised changes to ICE and CBP operational procedures.
What kind of specific changes might a court mandate?
Well, several things.
Yeah.
First, it could require agents to immediately verify citizenship claims with proper ID. Mandate that verbal claims can't just be dismissed.
Okay.
Second, it could mandate clearer identification protocols for agents. The lawsuit highlights the use of masked federal agents in plain clothes, which prevents accountability.
So, body cameras, visible ID tags.
Could be. Or specific verbal declarations of authority before any stop can proceed. It would fundamentally change how these sweeps operate, moving away from anonymity toward verifiable enforcement.
And a third outcome.
The third potential outcome is establishing heightened evidentiary requirements for initiating a stop. The court might demand that agents document in detail the specific facts that led them to believe someone was a non-citizen, forcing them to justify probable cause beyond they fit the profile. This lawsuit is fundamentally challenging the operational assumptions behind these large-scale sweeps, arguing they rely on unconstitutional racial bias.
So the long-term implication could be a whole new judicial framework for balancing security with civil liberties and domestic enforcement.
It could be.
This has been a critical and deeply detailed look into this legal conflict. Thank you for supplying the source material that let us explore the intensity of this challenge. We've seen how the ACLU is challenging mass enforcement in Minnesota on the grounds of racial profiling and constitutional rights violations, specifically impacting Somali and Latino U.S. citizens.
And we highlighted those truly shocking operational details that make this real. The headlock and detention of Mubashir Khalif Hussein, followed by that alleged pepper spraying retaliation while he was exercising his First Amendment rights.
Right.
And the alleged religious and linguistic harassment of Muhammad Idaris and his mother, including that request to remove her niqab.
And we now understand the crucial conflict of authority here. That sharp division between the federal defense targeting criminals and fraud, and the local government's condemnation of the operation as an unconstitutional federal invasion. Understanding these specifics, the individual traumas and the high-level legal terms, that's what separates being merely informed from being truly well-informed.
Right. And the key takeaway, reinforced by this entire lawsuit, is the idea that federal agents are not above the law even during these enforcement surges. And this raises an important and, I think, a provocative thought for you, the listener, to mull over. When federal agents operate without identifying themselves, using plainclothes and masks as alleged in the source material, how does that fundamentally change the standard of accountability required when they're operating in civilian areas? If the agent is anonymous, the injured citizen has no one to sue, no one to identify, and no clear path to justice. So think about that essential balance between an agency's stated need for operational security and the fundamental right of a citizen to know the identity and authority of the person who is detaining them. That anonymity, according to this lawsuit, may be the very tool that enables these alleged constitutional abuses.